Hello, today we're going to talk about 8 things to know about a power of attorney. And I'm Daniel O'Connor, a Georgia lawyer. So 8 things. First, a power of attorney is a document giving someone authority or agency to act on your behalf. So even though it says power of attorney, your agent doesn't necessarily have to be a lawyer if you sign a power of attorney. Giving them specific authority to do certain things. Second, a durable power of attorney is one that remains in effect even if you become incapacitated. So even if you get in an accident and you're under, you've been put under, or if you develop dementia, your power of attorney remains in effect. That's a durable power of attorney. Most powers of attorney, or at least general powers of attorney, are durable. 3, Georgia has a statutory form power of attorney that is pretty much universally accepted within the state of Georgia as a valid power of attorney. And this is a form you can get. We use this form a lot, and it's pretty dependable and it's easy to follow. However, number 4, real estate lawyers and banks often want a specific power of attorney for a specific transaction. So what I mean by that is, say you're borrowing $250,000 to buy a house. A lot of lawyers and banks don't want to just rely on your general power of attorney that you signed years ago that just gives general authority to someone to act on your behalf. They want to know that you really approved borrowing that much money. So often, even though you have a general power of attorney, you may need a specific one for a specific transaction, especially if it involves a substantial amount of money. All right, so the 5th thing to know is powers of attorney for a real estate transaction, at least in Georgia, require 2 witnesses, one of which must be a notary, which is also the requirement for a deed in Georgia. So the power of attorney has to at least meet the minimum requirements for witnessing that a deed would. So if you sign a power of attorney that only has a notary or only has a witness, then it's not going to help you if you need your agent to handle a real estate transaction for you. Number 6, the agent under a power of attorney cannot use your power of attorney to give themselves property. This is not a valid use of a power of attorney unless the power of attorney specifically says that they can give themselves property, which is frankly pretty rare. So, and most people wouldn't want to do that. They would just make the gift. But, so we see lots of times where people use a power of attorney to deed themselves property, and that's not going to hold up. So that's an important thing to know. Number 7, it's a good idea to update if you have a general power of attorney, to update it every few years. Powers of attorney that are 6, 7, 8 years old, they're still technically valid and may be accepted, but it's more likely that banks or lawyers or whoever is looking at it to determine that your agent actually has authority to act on your behalf may start being concerned that it's not valid anymore, that you may have revoked it and they just don't know it. So it's a good idea to refresh your power of attorney every so years. And number 8, you probably should have a power of attorney even if you don't feel like you need it right now. The reason is you never know when you might become incapacitated. So when we do estate plans, someone comes in to have a will made or a trust or something, we almost always also do a power of attorney and an advance directive, which is something similar to a power of attorney except it's for healthcare. We go ahead and do that. If you're married and you trust your wife or your husband, go ahead and make them your power of attorney so that they have it if something were to happen to you. So a power of attorney is only effective while you're alive. So if you got in a car crash and you weren't able to take care of your business, or if you develop dementia, at that point it's too late to make a power of attorney. You can't, if you're incapacitated or don't have mental capacity, you cannot make a power of attorney. You don't have the capacity to do it. It would not be legal. Therefore, having one in place already is very important. So we always include powers of attorney in our full estate plans. And you can even make it that it doesn't become effective until you become incapacitated. If you're going to do that, it's very important that you work with an attorney to make sure the language is just right and to make sure that it has the proper type of witnessing and notarizing. So I hope you found this video helpful. Powers of attorney are not a particularly interesting subject, but it's a very important subject. So if you have any questions about these, please feel free to reach out to us, and maybe it would prompt more questions, and we hope that we can work with you one day.